So the court would note, by way of background, Ms. Greider is the guardian, as I understand it, through the Otsego County Probate Court of Mr. Blom. She's the co-guardian along with her brother, and I think that was Matthew Blom. In any event, we're here today on Ms. Blom, your motion. This is a motion to set aside consent judgment of divorce. I've had a chance to read that letter in your motion, as well as the response that was filed by Ms. Greider on behalf of the father of the defendant, where she is the guardian. I've also had a chance to review the background of the other things. Ms. Greider, are you now connected?
Can you hear Christine?
No, I don't know if they know they're muted.
Well, we're not muted, Ms. Greider. In any event, I'm trying to put my screen so that both Ms. Blom and myself can be seen. That's not very easy. So what I'm going to do instead is just kind of have me in the screen so that at least the parties here that are via Zoom can see me while I'm addressing them. Ms. Blom, this is your motion to set aside consent judgment of divorce. What did you want me to be aware of outside of what you put in your written motion?
People who have, he has employed not as they say, he had an appointment last week to get a cognitive evaluation from a private psychiatrist. Mental hospital let him go because they hadn't made the appointment. They're working from paperwork on July.
The first thing that matters here is the judge narrowing the battlefield. Ms. Bloom is bringing up cognitive evaluations, the guardians, and concerns surrounding Mr. Bloom's care. But the court keeps separating those issues from the actual motion. That distinction is huge.
The mental lodge does a small cognitive evaluation every 6 months. So they did that and asked her, how did I do? She said, really good. So he went out front and asked to see it. Christine refused to let him see it.
Your Honor, I believe
the question, Ms. Blom, is whether or not you have anything.
Sorry.
Ms. Greider, I'm not sure what's happening with your connection, but it's very poor. I'm attempting to adjust the camera, and what I'm doing is allowing you to see Ms. Blom while she's speaking, and I'll switch the camera back to me when I'm speaking. You'll be welcome to participate in the hearing if you can get connected, but you're clearly not connected yet.
Your Honor,
Ms.
she's
Blom,
coming to my
question?
office so she can hear. She'll be here in just a couple seconds. We work together, so.
That's fine. Ms. Blom, the question that I had is whether or not you have anything in support of your request to have the consent judgment set aside. I recognize that there's a guardianship case proceeding, and there are separate issues in a guardianship case. So the issues in this case is not whether or not there's issues going on with Mr. Blom. The issue is not whether or not, for example, there's a need for continued guardianship. That's outside of this court's purview. Judge Hesselink has ordered the guardianship, and that will continue unless he orders otherwise. So this court doesn't have jurisdiction to address issues related to guardianship. What you've asked me to address through the written motion that you filed is whether or not I should set aside the consent judgment of divorce that you asked me to enter and that I did enter on February 6th of 2025. So what argument would you offer in favor of that motion to set aside the judgment?
We both would like to be married to each other.
All right, anything else you want me to hear?
The things that Christine put in the letter, many of them were not true. She said that he has, there's a letter from Mr. Manasseh, and she told him that he has money in his account. If you have somebody call, there probably is no money in the account. She keeps his $60 a month Medicaid. He has received no letters, no cards, no pictures, nothing from anybody. For Father's Day, there was nothing from anybody, not a call, not a Zoom, not anything.
How does any of that, if true,
Okay,
Ms.
but
Blom,
I'm the only one who has any contact with him at all.
Ms. Blom, how does that relate to whether or not there's a legal basis for me to set aside the consent judgment of divorce? Because that's what you've asked for, is for me to set aside the consent judgment of divorce. As you know well, because you were represented by counsel at the prior hearing, I held a hearing regarding whether or not I should set aside the consent judgment of divorce. And while I'm understanding of the fact that you disagreed with my ultimate conclusion, I ruled upon the motion, and that was over a year ago now, or almost exactly a year ago now. What has changed in the last year such that I have authority to set aside a consent judgment of divorce that's now 18 months old?
I guess just the fact that we want to be together. We're both gonna be 82 years old this year.
Even if I were to say that the consent judgment of divorce were to be set aside, you understand there is still an ongoing guardianship
I
case.
understand that.
You understand that the guardian, because she's been appointed by the probate court, still has the ability to make care and custody decisions with regard to Mr. Blunt. You understand that?
Yes.
But until Judge Hesselink orders otherwise, all of those terms of the guardianship or the conservatorship will continue. You understand? So the point that I'm making is, what about your request? How would I support under Michigan law the ability to set aside a consent judgment divorce that you asked me to enter and that I entered 18 months ago, now today in August of 2026? What authority would I have to set aside an 18-month-old judgment?
The situation back then, when you make that decision,
When you asked me to make that decision,
I'm sorry,
when you asked me to make that decision, you were the plaintiff. You asked me to enter the judgment, ma'am.
I asked you then to change it. My attorney put in briefs, which was appropriate. Their attorney sent you emails. And you said, no, that wasn't appropriate, so you weren't gonna let either of the attorneys speak. And that-
Well, I don't need to let the attorney speak in the law, and that is plain and established. When I have briefs, or whether or not I have briefs, the law allows me to dispense with oral argument. I'm not doing that today. I'm going to give you an opportunity to be heard. But in terms of the background, you would ask me to enter a judgment. I took proofs. I entered the judgment because I determined that the proofs were in order.
Now watch this, because the record itself starts becoming the judge's strongest reference point. Miss Bloom challenges how the earlier proceeding was handled, particularly the lack of oral argument and what attorneys attempted to communicate. But the judge isn't treating that disagreement as proof that the divorce judgment was legally defective.
You then, some months later, asked me through your attorney to set aside that judgment. I wasn't convinced at that time there was a basis to set it aside. Your attorney was convinced that there was a basis. I was not. After that time, I know that you made assertions that I should have considered whatever the other attorney stated. But as I stated at the time, the other attorney didn't file anything timely. They sent things to me inappropriately and on an ex parte basis, and that's why I didn't consider them. The question, though, again, is because you're the party asking for me to set aside the consent judgment divorce, what legal authority exists for me to do that now?
That's what you ruled before? I don't know.
I ruled before not to set aside the consent judgment divorce. I ruled against your request to set it aside.
Yes, you did.
Right, so I denied it at the time because I was convinced then that I didn't have the legal authority to set it aside. Because you had asked me to grant the divorce. I took proofs from you in support of the divorce. I had your signature, Mr. Blom's signature, and your attorney's signature. I viewed that all of the statutory grounds for the judgment to be entered were met, and you requested that I sign it. I signed it. Then I determined some 4 months later that there wasn't a basis to set it aside. What other basis is there for me to set aside the judgment now? I mean, I recognize it sounds like you disagree with what Judge Hesselink has ordered in the guardianship case, because you want to be able to have contact with Mr. Blom.
He won't let Ed speak.
Right,
Ever.
right. But that's in the context of the guardianship case. How does that relate to whether or not I should set aside the divorce judgment?
It's a little muddy here. Judge Hesselink should have recused himself from any of this simply because he represented Ed's wife in their divorce. They used to socialize. They all went to E-Free Church. So Judge Hesselink and his wife, and Ed and his first wife, were on committees together at E-Free Church, and they were they socialized together.
Even if I were to find that to be true, and this is not a case where I have superintending control over the probate court of Otsego County, but even if I were to find that to be true, how does that, even if it is true, relate to my ability in the context of the divorce case to set aside the divorce judgment? It sounds like what you're saying is you have a problem with the guardianship case. You have a problem with Judge Hesselink presiding over it. You have a problem with the decisions he's made. You have a problem with the guardianship, the guardian's decisions in that case. How does any of that relate to the divorce case?
Ed would like us to be married. I would like to see him married. We don't, we're both, like I said, 82 years old. We don't know if we have another day, another week, another year, whatever. We just want to spend it. That's all. That's all we're asking.
Right. Thank you, Ms. Blum. Ms. Greider, as the guardian of Mr. Blum, I had a chance to review your written response. Outside of your written response, and as to the particular question of whether or not the court should or can set aside the consent judgment of divorce, did you wish to be heard?
Yes, sir. I'm sorry, Your Honor, I was having no audio in my office, so I came down to my sister's office. So I'm currently listed under Betsy McKenna, but my name is Christine Greider, and I'm co-guardian and co-conservator of my father, Edgar Blum. We object to this motion, and we ask for it to be dismissed. We believe the original motion up for divorce contained no fraud, no coercion, no extraordinary circumstances. And since it has been over a year since granting the divorce.
This is where the argument starts drifting into dangerous territory strategically. Ms. Bloom raises concerns about the guardianship judge, including past social and church connections involving people connected to the case. That may sound significant on its face, but this judge immediately asks the question that matters here. What does any of that have to do with reopening this divorce?
Court to dismiss the motion.
I believe this is has timed out. It has expired to even be brought before the court.
Thank you, Ms. Greider. I appreciate having input from the parties today. As I indicated already, and the parties are well aware because I've exercised my discretion differently in the past, the law does not require that I hear from the parties if I have enough information. And in this case, I do have enough information because this issue is not the first one that I've decided on this exact point. Ms. Blum, I understand what your contention is. Your contention is you want to be able to spend the rest of your time that you have with Mr. Blum. There's nothing wrong in particular with that as a concern of yours or a goal of yours, but that's not the issue before the court. The court has no magic wand that it can extend to simply say you can be married to Mr. Blum or you can have contact with him. That's because in the context of this case and in the context of the guardianship case that's ongoing before Judge Hesselink, there are independent legal and factual concerns. In the guardianship case, first, while you have made statements that you think Judge Hesselink should not be involved in the case, that's not properly before me. I do not sit as a superintending control judge over Judge Hesselink's determination. And I've not been asked to do that in this case. And even if I was asked to do so in this case, I don't have that authority to make a determination independently about whether or not Judge Hesselink should or did properly resolve that case. What is clear in that case is that there has been a guardianship hearing. There was a guardianship determination made by that court. And Mr. Blum has a guardian. That guardian I've heard from, and she has the right to be heard as the guardian in terms of whether or not I should grant this motion. But the point remains that in this case, this was a consent judgment divorce. It was a consent judgment divorce after originally Mr. Blum had a default issued against him. That default was issued because he had not properly answered the complaint. But even after that, Mr. Blumberg was approached by you and he was requested to draft the consent judgment divorce. It was drafted by him. It was brought to me as a hearing on February 6th of 2025. And what I repeated at the prior hearing, and I'll repeat again today, is my review of that hearing wasn't as clear. My recollection of the hearing is that Mr. Blum was never present. You were present separately. Mr. Blumberg was in his office. We waited some time for you to be able to connect. And when you connected, you were put under oath. Your attorney went through the statutory grounds for the issuance of the judgment of divorce. He went through the judgment in the general detail that was necessary. And he confirmed that you were asking me to issue the judgment of divorce. Hearing no input from Mr. Blum, but seeing his signature on the document, the court was convinced that the statutory grounds for the issuance of the judgment of divorce had been met. I also made the implicit findings when I granted that there was no fraud, there was no coercion, there was no undue influences, there was nothing extraordinary about the case. It was a standard, as I would say, judgment of divorce entry. It was only after that time period, about June, late June of that year, 2025, that Mr. Blumberg then filed the first motion to set aside the consent judgment. And that was set for a hearing before me. I think it was in August, early August of 2025. The day of that hearing, I received a bunch of different documentations from the attorney on behalf of either Ms. Greider or Mr. Blum in terms of the guardianship background and all sorts of other documentation. The way I received that information was completely improper. because part of it was email communications to my staff that was intended to be conveyed to me, as I understand it, as information, substantive information about a case that was improper. And I told the attorney on the date of the hearing, it was improper. I would not consider it properly received information. And because of the timeliness or lack thereof of when I received it, I didn't consider any response at all. It wasn't timely filed, and that's not how courts are supposed to do business or allow business to be done. So I didn't allow it to be done. I made my determination based only upon Mr. Blumberg's motion, which was in large part identical to this motion. It was a motion asking me to set aside the consent.
This is where the argument starts drifting into dangerous territory strategically. Ms. Blum raises concerns about the guardianship judge, including past social and church connections involving people connected to the case. That may sound significant on its face, but this judge immediately asks the question that matters here. What does any of that have to do with reopening this divorce?
And the basis that Mr. Blumberg offered is that he believed that now that there was a case in 2025, a guardianship case, it might have been the fact that Mr. Blum was not competent at the time that he signed the judgment of divorce, and that I should therefore set aside that judgment. I wasn't convinced in 2025 that there was a proper legal basis for all the reasons I indicated, most specifically that when Mr. Blum had the opportunity to be heard, he wasn't heard. Mr. Blum didn't call upon, Mr. Blumberg didn't call upon him. And the court never heard from Mr. Blum, only saw through his written signature that he had ever been involved. So I didn't address the issue of competency. It was never raised to me. It was never raised to me until months after the divorce judgment was finalized. I also noted that there was no basis for me under Michigan law that I was aware of to otherwise set aside the judgment. So I didn't grant it. In your motion, I think fairly stated misunderstands the background, because your motion, even your written judgment or your written letter in this case, suggests that I set aside the consent judgment on August 7th of 2025. No, I refused to set aside the judgment for the reasons that I indicated. It was also the next paragraph, you claim that my decision was to deny the consent judgment, which meant that you to remain divorced, even though you did everything according to the law. The only response that the court has is you did everything according to law to get the judgment entered. You requested the judgment to be entered. I granted the judgment after you entered it, after you asked me to enter it, and once you signed it, your attorney signed it, and Mr. Blum signed it. Nothing that has been done after the judgment's entry, though, has been according to law in terms of providing a legal basis for setting aside that judgment, especially not now, 18 months later. Again, I recognize what your stated intent is you want to be married to Mr. Blum, you want to spend your time with him. But I would reiterate, I would repeat as a finding that even if I were convinced that there was a legal basis to set aside the judgment of divorce, I'm not convinced of that. But even if I were, that would have no impact on, no bearing on, and no effect on ultimately what still is going on, which is the guardianship case. So even if I granted the relief that you asked, what you want, what you're asking for directly wouldn't be possible under my order. It's a further reason to not grant it, because what you think that you're going to get out of having a set aside judgment is not what you're going to get, because ultimately the guardianship is in place. The guardianship, if it's going to be challenged, is challenged within the context of the guardianship case. And if you think that the guardians, Ms. Ryder or Mr. Blum or anyone else has acted inappropriately, you have the ability to challenge the guardianship, but you can't challenge the guardianship through the divorce case. The divorce case was and is final as of February 6th of 2025. So I understand you view this as an important case. I don't view it as unimportant, but the legal basis is lacking for me to set aside a judgment of divorce 18 months later after it's been filed. And there's no other basis for me to set aside the judgment. And again, it wouldn't accomplish the goal that you're seeking to accomplish. So for all of those reasons, the court finds that there's not an appropriate basis to set aside the judgment of divorce. If you wish to challenge any of the findings of Judge Esselink in the context of the guardianship case, that is the venue to do it. So I'll issue an order that just indicates for those reasons on the record, the court is not granting the judgment, not granting the motion to set aside the judgment. Do you have any questions regarding the court's order, Ms. Blum?
I have something I would like to read.
I'm not asking if you have something you'd like to read. This is not the time for additional input. It's a time if you have a question regarding my order, I'll to clarify what my
No, I
order
think
is.
it's,
So the court recognizes that you want to read something for the record, but the court doesn't find that to be appropriate. I've heard your indications. I've ruled upon it on the merits. I've heard from Ms. Ryder as the guardian of Mr. Blum, and I consider the matter now resolved. to the court. The next step is if you wish to challenge the guardianship or any of its provisions, that case is done in the Otsego County probate court, not the Otsego County Circuit Court where we're at now. Ms. Greider, on behalf of Mr. Blom, do you have any questions regarding the court's order?
We do not, Your Honor.
The court will stand in recess then. I will issue an order that clarifies for the record my findings today.
Thank you, Your Honor.
Now we reach the issue with potentially serious legal significance: competency. The earlier argument apparently suggested that the later guardianship raised questions about whether Mr. Bloom had been competent when he signed the divorce judgment. But the judge identifies a major timing and record problem. Competency wasn't presented to him when the divorce was entered, and Mr. Blum wasn't called to provide testimony that would have put the issue directly before the court. The judge says he only had Mr. Bloom's signature showing his involvement. This is the point where the practical problem becomes just as damaging as the legal one. The judge recognizes exactly what Miss Blum hopes to accomplish: restore the marriage and spend time with Mr. Blum, but explains that undoing the divorce wouldn't dismantle the guardianship. That means even a victory here would not automatically produce the result she wants. Strategically, that's devastating because the requested remedy is aimed at the wrong legal mechanism. If the guardianship itself is restricting contact or controlling Mr. Blum's care, that dispute has to be addressed inside the guardianship proceeding. The divorce court can't be used as a side door around it. At the same time, the judge says he lacks a sufficient legal basis to disturb an 18-month-old final judgment. Those two problems reinforce each other. The requested relief isn't legally supported, and even if granted, it wouldn't resolve the underlying conflict. The final exchange shows the courtroom power shift clearly. Once the judge has ruled on the merits, Miss Bloom wants to read something additional into the record, but the court limits the discussion to questions about the order. That isn't simply impatience. There's a procedural endpoint to a hearing, and allowing new argument after announcing the ruling could blur that boundary. The judge makes clear that he has heard Miss Bloom, considered the guardian's position, and regards this particular motion as resolved. Just as importantly, he identifies where any continuing fight belongs: the probate court handling the guardianship. That leaves Miss Bloom with a difficult distinction. The court isn't saying her desire to be with Mr. Blum doesn't matter. It's saying this divorce case cannot legally deliver the remedy she's seeking. And that difference between a powerful personal reason and an available legal remedy ultimately controls the hearing.